Good morning, Sushant ji. Welcome aboard on this program that we have
Good
today.
morning.
All right. So, good morning, participants. Thank you for joining in. The session is brought to you by IPPO. As you all are aware, what IPPO is, IPPO is an organization which is bringing awareness and intellectual property in various fields. We connect with the institutes, the various universities, and conduct programs on intellectual property. So today, IPPO brings to you a topic which is very uh, touchy to the heart, which is the social media. And we have with us Mr. Sushant Singh. He is a skilled lawyer and litigator and has more than 12 years of experience as a lawyer and about 15 years of overall experience in the legal field, which means the core areas that he covers is in the field of intellectual property law and other commercial laws, pursuant to managing his own law firm, having 15 experienced associates in India. While managing the firm, he has collaborated with clientele which include renowned multinational corporations originating from the US, Canada, UK, France, Japan, and other countries. The Government of India undertakings, Indian companies, startups, individual clientele, university professors as innovators, solicitors, legal heads, and partners of firm are of international repute and stature. He has skills like persuasive argument skills, the litigation management, exceptional negotiator, an avid reader, a strong leader, tireless worker, ethical client counselor. And he has had a varied experience in terms of managing the firm as uh, head, the advocate, the associate advocate, and then managing. He also has achieved milestones in his recognized as the top tier in listing of firms between the period 2008 to 2016 in the field of intellectual property for prosecution and litigation. He has filed more than 20,000 registration cases. He has represented more than 1,000 clientele. And today we have the pleasure of having him on board with us on the topic that is unlocking IP and social media. So we welcome you on board, sir, and we look forward to
Thank
having
you.
a very interesting talk coming in because I'm sure the social
Thank
media
you.
is such a thing which is happening with every individual that we see today. And people are like,
Agree.
wanting to be on the social media and still are able to protect the various rights that they can. So thank you for
Agree.
joining and we look forward to hearing from you, sir. Thank you.
Thank you. Thank you.
So,
One thing I want to point out. One of our company, clients, legal manager. They want to
mhm,
join,
sure.
and one of the president is also vice president of the company is also joining. So those people
Right.
are waiting, to join. So
Most
kindly let
welcome.
them in. One senior level person is Ms. Meera Vanjari. She is
Okay.
actually from Glenmark Pharmaceuticals. She is
Okay.
actually waiting. If you want, I can give
Sure. Sure.
so
Please
that you
pass.
can contact her because she has messaged me. Yes. So please kindly contact at 98202
Yes.
98202 85465.
Sure. I'll do that, sir. And the meeting
So
is open. So in
during
case, yeah.
while the time you were introducing me, that time
Okay.
at
I'll
that
talk to
time
her.
she mentioned to me just right now she messaged me that I'm unable to join in.
Sure. I'll
Thank you.
just check back with her. Sure. And
So
you can begin. And Kunal,
should
you
I
can help,
start?
sir. And yes, sir. Yes, sir. Please. I'll go on mute. I'll go on mute for the time
Right.
being, and I'll connect back with you. Sure. Thank you. And
Yes.
participants, please have the best
Yes. Yes.
opportunity
Thank
of
you.
listening to Sir. And please raise the questions in the chat box, and we will be able to answer them towards the end of the presentation. I'm sure most of it will be covered during the presentation, but if there is any unanswered, we'll definitely cover that after the presentation. Thank you for your patience till then. Yes, over to you.
So yes. So good morning, friends. It's always pleasure to have you here. And this today we are discussing a topic which is very close to the heart of everyone, which is social media and intellectual property. Why I have chosen this topic at present is because, as you are aware, that we are in COVID times. So to lighten our heart, we have got this, social media in our kitty, whereby we can enjoy, we can have lightened movements, we can laugh, we can share data, and so on and so forth. So I will start with the PowerPoint presentation, and I will ask my colleague, Mr. Kunal Khanna, to share the screen with me, please. Thank you. Yes, so we will start this slideshow. So here we go. We will let us come to the first page. Yes. So the topic, as you are aware, IP in the age of social media, which is that what to do with the intellectual property rights enforcements in the social media time. So I will start with the first one, which is the brief introduction, which is the next slide, that we are living in the age of information revolution. It's an information age. And you are aware that the concept of property has been changed. It extends to intangible. Now, with the click of button, you can share documents, you can share pictures, you can share anything under the sky, maybe joke, maybe motion picture, everything. So the scope of and horizon of internet has expanded over the years, and internet is now such a thing which is affecting the life of everyone today. And even now, we have realized during these pressing times that it is actually more than a part of fundamental right, or I would say a part of living. Next slide. Now internet has got certain things which are certain facets which are connected with commerce. As you are aware, we can have e-commerce. I have read the book of Modern Law of Copyright by Justice Laddie, who describes internet web page as a shop front. It is a substitute for a shop front. So today, when we hear the ad of Amazon, we hear them, "Aapki dukaan, Hindustan ki dukaan." What is the significance of that when Amazon calls that "Aapki dukaan" or Hindustan ki apni dukaan? It means that the shops which has been substituted by the e-commerce website. And yesterday I've seen that Jeff Bezos' turnover was announced, which is $200 billion, which fortifies this position that internet web page has substituted a shop front and performs the role of branding. Now, I will give some example to just for the people who are familiar or who want to educate themselves, which is that we bank online, we shop online, we book holidays online, we shop physically through internet, through electronic credit card, we do Facebooking, tweeting, WhatsApping, so Skyping, maybe share chatting, so many things. What does it imply? It implies that our karma has now been eaten over or taken over by the internet most of the times, not one of the time. Nowadays, the jumla will be we litigate online. And we do court matters online. So, which is addition. When I prepared this slide, I was not too much keen to write that we litigate online, but now we litigate online also, and most of the time in COVID times. Next. Now, now, what is the part of social? What is social media? People always tell, they confuse internet with social media. Social media is only one set of proposition, or we would say one set of facet of internet, which is which is one of the broader chunk of the internet, which internet is a medium whereby it facilitates the exchange of information, whereas social media is an interactive computer mediated technology. It is, as per Wikipedia, it is actually an interactive computer mediated technology that facilitates the creation and sharing of information, ideas, career interest, and virtual communities and networks. Now, how it is interactive, I give you an example. Now, if you see Facebook, you can do chatting, you can send information, there can be data exchange, you can have a career interest exchange in the form of LinkedIn. So this is the definition given by Wikipedia, and it has got the following salient characteristics, which is interactive Web 2.0 internet based application, user generated content. This is also very important. Now in WhatsApp we receive TikTok, which is a user generated content, or when we do forwards, it is not created by the social media providers. Those are merely platforms, and it is actually a user generated content which is being utilized as a medium for doing business in the social media. Third is user created service specific profiles. Now, in certain cases, like in the case of Facebook, there are profiles, or in the LinkedIn, there are user generated profile where one can actually prepare a profile and then do a business. Now, Facebook has extended its model even to businesses, and you can do marketing also. So all these things are the salient features of the social media. Is this next part is the social media is a medium and is a facilitator. At this part, I've already covered that social media's websites only propagate, that they are the medium, and it is only facilitating the user-generated content, which in the form of pictures, videos, documents, PDFs, JPGs, and other kind of content which is transferred through social media platforms. Next slide. Yes, so now I will also, because I've given the Wikipedia definition, I would not go discriminatory about it. I will also give the definition of Indian jurist definition, which is given by very articulately by Justice Shahrukh Kathawala, sitting in Bombay High Court, where he perceives social media in the case of Mariko versus Abhijit Bansali by observing the following. It says social media is influencing is one of the most impactful and effective way of marketing and advertising. A social media influencer who has or claims to have a sound knowledge on what they claim to be their niche and uses their knowledge to influence people in believing and subscribing to the same set of ideas and thought trying to propagate on social media. It says this mindset can be changed. One can change the mindset through social media. This mindset can be changed for better and scarily even for the worse. Now, what does it imply? It implies that the learned judge, who can be said to be one of the hard-working judge because he used to run the court at about 2:30 a.m. in Mumbai High Court. That person. He has mentioned that he has becoming familiar and abreast with the today's issues which we are facing, and it's a reality check, which is that social media is actually a perception making institution, and it can change the mindset of the person by looking at the social media even for good and even for worse. Now it is our judgment whether we want to make it for good or whether we want to make it for worse. And ultimately, since it is a major influencing factor that in our behavior pattern, because we have no more things left over, like we have got television and a second alternative is social media. Therefore it changes the perception of the individual, the way he sees the ideas, the way he sees the information circulating, the way he sees the insults or the injuries or the tarif or the or boasting and reputation. He makes an opinion basing upon social media information. Next slide. Okay, so now we have learned what is social media. Let us also bifurcate what is social media in terms of classification. Social media, we don't classify all in India. People are not aware about nitty-gritties. Therefore, I thought that it is better to break down. Microblogging. Microblogging is an area where one can write short notes, short blogs, and such kind of facet is there in Twitter. We know the entire politics is going on Twitter. Everybody is sharing idea on Twitter. Even health updates are given on Twitter. So it's a microblogging. Social bookmarking. Now, what is social bookmarking? Social bookmarking is when you have got a particular interest in geography, in history, or maybe in Bollywood, Hollywood, or other areas or other sectors which are entertaining, educating, etc. You can pin your interest. So it is actually pin interest, which is social bookmarking. You can pin up that particular interest by in your phone, and you will get the continuous updates. Social news. Now, what is social news? Reddit and Dig, wherein you will get who is doing what Bill Gates is doing, what Andrew Cuomo is doing, what Microsoft is doing. So these updates in the social media, what Jeff Bezos is doing, all these things in the social media updates and the social news is done by Reddit and Dig, and all these are such where user generated content can be there. You can also do post your updates in the said website as a voluntary individuals. Multimedia websites. Now these are for video sharing. Like this video webinar will be uploaded possibly on YouTube, so people will see there. Maybe Pinterest, maybe MySpace.com. They perform twofold function. One is they provide the space, and another is they share the videos information in the form of motion picture so that people can see. Social networking. Now, social networking can be professional networking, which is like LinkedIn, career interests, and all, wherein you can build up your career on LinkedIn, or maybe Facebook, which is more of a casual interest, where you can deal with your friends, where you can introduce with the new friends informally, formally, and you can meet up also. There are some additions also. Maybe I would say social networking may also extend to dating app, matrimonial apps, which are all social networking, which will build up relationship building. So I will categorize them separately, which is not there in the slide, which is relationship building through social media, which is the next function of social media. Next slide, please. Okay, so let us start with little bit of stats, which is that as per December 2018, 566 million users were online in India. This is Live Mint, which is a newspaper online. Statistica says 326.1 millions were social media users. There are other Hotsuite, which is a website again. It says 290 million active social media user access social media through their mobile devices. Now, mobile has also become a very significant contributor for access to social media because there are pre-installed apps, and the mobile is nowadays not merely a phone. It talks to you through social media. There are virtual software like Siri. Siri will do everything for you in Apple phone, and likewise in Samsung phone. There is another nomenclature which is given to which talks to you, and by doing that you can have an access to social media. 97% of Indians were connected to internet and watch video online. So these are, what does it imply? It implies that there is a diverse interest in video watching, there is a diverse interest in sharing the information, there is a diverse interest of Indians that who want to have a social relationships, or maybe want to access the social media. Facebook has got 241 million active users in India. So because that's which is the largest in anywhere in the world, because India is the largest country. So this can show how people are attracted towards social media and how big is the impact of social media upon the lives of our individuals, including today's time, which is COVID time. I will again say that. Next slide. Okay, so although I have discussed the consequential effect in practical terms, because the more the users, the more data sharing, the more video sharing, the more sharing, frequent infringements of intellectual property rights, more traffic more traffic on internet. There are too many opinions on the subject, leading to conflict-like situation, like political and social issue. We see every day politics of one right wing versus left wing doing the very thing, fighting with each other, which is a reconciliation of opinions. We are facing with the issues in Twitters and other blog websites every day. Someone says Sushant Singh Rajput was murdered. Someone say Ria is innocent. So all these conflict-like situation in on Twitter are militating against each other, which is opinions versus opinions. Data like photos, information, news are not genuine sometimes. They are fake news. 1 minute ago, it says that Chief Justice is opening the High Court and Supreme Court. 1 minute thereafter, it says it's a fake news. So all these are the fake IDs, impersonation, leading to problems of defamation, commission of criminal offenses. All these are the problems which are there with the rapid increase of social media access. So the more the information sharing, the more the user generated content is sharing, the more issues crept in. Those some of the issues are identified, some of the issues are still yet to be explored, whether those are forming within the realm of legalities or illegalities. I will share some of them as an examples in intellectual property perspective. Next slide. Okay, so legal problems. Some of them are very much identified. I will quickly count them on fingers, which are that the legal infractions emerging from various constitutional and legal rights, privacy law issues. As you know, Justice Chandrachud's judgment of Puttaswamy, which talks about privacy rights. So privacy rights are infringed if somebody puts his girlfriend's picture online. There would be a privacy right infringement. Personality rights, if somebody uses a Amitabh Bachchan picture and without his permission, it will be personality right problem, damage to the goodwill. Defamation, if Swami Ramdev's book has been published online which contains the denigratory material, it's a defamation. Commercial and consumer protection dispute, this I will also come again in the last, because there are guidelines which have been passed recently on 23rd of July, which also takes into consideration the purview of e-commerce websites and consumer disputes. Immoral legal issues, pornography, indecent representation of women. There are several other uncharted areas where the clarity is needed and the legal issues will arise in future, because it's a diverse nature of data sharing leading to diverse legal consequences. Next. Okay, so I'm narrowing down the topic, which is the basic theme of today. What is social media and IP issues? Broadly speaking, social media and IP issues can be subcategorized into following perspectives. One is commercial disparagement, which is a species of defamation in IP regime. And second is patent, third is trademark, copyright, and trade secret. There can be a design infringement also, but we have not seen any recent case of design infringement as of yet because it's on the three-dimensional object. But these are the core areas where visible eye can see the infringement. Next. Okay, so legal hurdles. Prior to discussing the examples, let us understand what are the legal hurdles which are there in social media. Before reading this, I would like my audience to actually understand how many stakeholders are there. One is the person whose right has been infringed. Second is the person who is infringing the right. Third is the person which is a social media platform. Fourth may be a person party whose right might have been infringed incidentally or ancillary. And there may be other stakeholders also if more than one person's photograph is involved, and maybe it can lead to also an infringement of their right. So what are legal problems? Because social media can be flashed anywhere, jurisdiction of a court is one of the principal legal issue which is troubling the courts nowadays in tackling the social media infringement. Because if a company belongs to Mumbai and the experiment is initiated in Calcutta, which is viewable both in Mumbai and in Calcutta. The question will arise whether the court will have omnibus jurisdiction or whether it will not have omnibus jurisdiction. So therefore, the jurisdiction, and there are foreign elements, which is a second point in the civil dispute. When foreign element or foreign party is involved, then also the rules of private international law comes into picture. Whether they should be the person should be restrained on worldwide basis or not, whether Facebook as an American party should be restrained or not. These are the complex issues. What are the other problems? Social media platform says that we are merely facilitators, as we have seen in the definition of social media. They only say that we are merely the platforms. We have nothing to do with the user generated content. And how can we filter that content? And the government is now grappling with the same problem. They are becoming more stringent on social media. Recently, they have banned TikTok because of this reason also. One of the reason was this also, that the mockery and the mimicry element was there, which results sometimes into insult and sometimes into defamation as well. So now the point is that social media companies normally take up the defense under Section 79 of the IT Act, which wherein they say that they are merely facilitators and they are not contributory to any kind of infringement. Next is that social media company regulates infringement of IP right by providing takedown policies. Now, this you can say as a hurdle, or this you can say as a characteristic, because every website has its own policy. One policy says we will respect the legal rights. Another policy says give us 1 week time. Another policy says give us 14 days time. So the practical problem is that there is no uniform policy. Though now the IT law amendments have tried to uniformly give the time period of 3 days, 36 hours to take down the thing. But ultimately, the websites which are foreign in nature may or may not agree with the said law because they are not subject to Indian law, but which result into litigation. But this is a kind of, one can say, a hurdle to litigate. If you want to litigate, then it is a kind of hurdle because the social media websites, they take the refuge of their own policy by saying that we have our own policy, we will take down this, and thereafter try to escape the liability. The next slide. Okay, so this is a format of a Facebook policy as a template which I want to share with you. One or two points I will read and then we will proceed further. We respect other people's rights and expect you to do the same. You will not post any content on the Facebook which infringes or violates somebody else's rights or otherwise violates the law. And thereafter there is a infringement of intellectual property clause also. If you repeatedly infringe other people's intellectual property right, we will disable your account. What does it imply? It implies that intellectual property infringement is a key factor which is also coming into play, or I would say that this is, if not a direct stakeholder, but an indirect stakeholder other than the parties. Intellectual property right of an individual has a stake which is independent to that of parties when it is infringed at the social media. The next slide. Okay, so the skeleton arguments of social media companies, as I say, social media's companies' fate in the litigation is more or less predictable in most of the cases. Why? Because companies argue that they should be removed from the litigation because they are merely facilitators, so they are not direct contributors to infringement, so they should not be implicated in the litigation. They say that they are not jointly and severally liable. They say that they are not direct participants. So by doing this, they sometimes the line between honesty and dishonesty get blurred, and sometimes there is a direct involvement of social media company. But they when they take the refuge of Section 79, it sometimes boils down to judge inquiry, by case inquiry. In some cases, they are exonerated when the learned judge or the court is able to understand the problems of the uh, collusion between social media company and the defendant. In such cases, they are retained as a party to the proceeding. The next slide. Okay, so I was talking about Justice Kathawala's opinion. This is, I would say, one of the first disparagement case, to my mind at least, which has been decided by Justice Kathawala in the case of Marico versus Abhijit Bansali. What was the facts of the case were very interesting. We are aware that on the social media, particularly on YouTube and Facebook, there are various videos which are there where one can review. Now one can review and tell the product how to operate and how to function the product, what are the advantages, what are the disadvantages. Now in this particular case, a person who was the oil merchant of a virgin oil tries to compare the product called Parachute, and the top headline of the same, of the first page of the video was, "It's not as good as you think. Prove it." The next line was, "आज इस वीडियो में we are going to talk about most reputed companies, and one of the reputed company in the Indian market is Parachute coconut oil." अगर आप इसको यूज करते हैं, तो किसी को जानते हो कि वो यूज करता है, तो इस वीडियो को जरूर देखें। Now, what actually was a problematic for a parachute people were that he was not merely a consumer who was reviewing this article, or reviewing this product. He was a person who was himself selling a version oil. And how can he write a headline that it's not as good as you think? And Justice Katawala, in his usual academic scholarly style, after analyzing the law relating to disparagement, passed the injunction order with the detailed thumping judgment. And according to me, that judgment was needed, and that was the requirement of the time, where defamation or disparagement, commercial disparagement, is one of the essential facets of IP right infringement with respect to comparison of the product. However, the next slide. However, unfortunately, the division bench of the High Court of Bombay was overtly impressed by the argument of freedom of expression. Now, they they applied the classical doctrine of freedom of expression and confused the issue with respect to commercial disparagement and defamation, or freedom of expression under Article 19(1), and thereafter agreed and thereafter impressed upon parties to modify the ad, and they set aside or modified the order of the learned single judge. Now, what I feel about this judgment of the division bench, this is my personal opinion, though not criticism, that there lies a distinction between commercial speech and the freedom of expression. Freedom of expression does not allow you to denigrate the product of the competitor. There are inherent restrictions which are there in the commercial speech, where one competitor cannot gain edge in the market by defaming or pointing out the disqualities, or non-qualities, or rather saying that it's not good or worth it, which is not even a non-quality, which is a kind of exceeding the line of up till the level of defamation. I am personally of the view that, considering the fact, look at the contrast. Bombay High Court doesn't even find the judgment of Parachute, where it says it's not as good as it is worth it, which is a commercial speech. And look at the Supreme Court, which only with the tweet of Prashant Bhushan says that the democracy is demolished. So this is a contrast. Now, if according to me, this was far more denigrating than that of Prashant Bhushan remark. Though that are my that are my personal opinion. But that tweet was merely generic in character, where Mr. Bhushan was talking about personally about the quality of the judgments of the courts and everything. Whereas in the present case, the parachute product has been directly hit by the competitor. So I think the single judge's order was more convincing, because his speech was remarkable to the upliftment of jurisprudence of social media and IP rights. The next slide. Okay, so next case, which is a little bit of a lighter side, I would say, which is that there was in the Delhi High Court, there was a Corona beer case during COVID times, wherein someone was advertising Corona beer with the coronavirus, and he flashed the advertisement on Facebook, stating that you will get coronavirus if you drink Corona. And he has actually tried to also link the coronavirus pathogens, or I would say viruses. It says it's a roll on virus, just like if you can see on the screen, one bottle which is connected with other viruses. So you will get the virus, so stay at home. Mr. Anand, Praveen Anand, he did the case in Delhi High Court. And ultimately, the learned single judge, Justice Rajiv Shakdar, granted the injunction because it's a dilution of the goodwill, which is of Corona beer, which is very famous Mexican beer. So this is one of the example of trademark infringement. We are now heading towards the example. I gave you an example of commercial disparagement. Now I've given you the example of trademarks. We will head towards other examples. Next slide. Okay, so one case which is decided by the Delhi High Court was Da Milano case. In the Da Milano is also, as you are aware, a leather-based company selling wallets and belts and other leather-related items. In this case, the directions were passed against Facebook and Instagram based upon the rules which I have shared with you that the new rules have come into place in the year 2011, which gives a time period for a social media platform to remove the offendable content. So the court has directed that the plaintiff shall inform Instagram and Facebook whenever they come across Da Milano, either in word form or in logo form. Then it says that as per the rules, the parties they will inform the platform and they will remove the same. And if they don't remove the same, Da Milano will have a right to approach the courts, competent court of law. The next slide. Okay, so the next one. The next one is the copyright case. It is also very funny, I would say. One manager, Mr. Bhupinder Singh of Fairmount Hotel, had opened his own hotel in Manali called Mountain Inn and started putting the photographs of Fairmount Hotel on the Facebook page to attract the consumers. So it is a kind of, I would say, uh, usage of a picture rights or artistic work of a hotel which is belonging to Fairmount Hotel, and without permission, he was using the pictures on the social media, which resulted into ex parte order and later on the decree by the Delhi High Court by Justice Manmohan. The next slide. Okay, so this is the previous one. Uh, yes, so this is another interesting case of Dainik Jagran, wherein the grievance of Dainik Jagran was that Dainik Jagran was having a subscription accessed only when public supplies, when public subscribe to the online website of Dainik Jagran. But what happened was in this case that someone in the Telegram, which is another social media app, actually tried to create the channel whereby newspapers of Dainik Jagran were distributed for free during COVID times. So the court found that it is not possible that somebody is trying to circulate the information free when it is a paid newspaper subscription for the earlier archives. So the court restrained the party and the telegram, in fact, and asked them to actually turn down the the take down the offending posts. So this is a copyright case again, which is for content. The next slide. Okay, so this is one of the unique cases which is on hacking, IT law, and social media. Case versus YouTube. In this case, what happened was, as I have already indicated, that with the social media, you can perform number of functions. In this particular case, some person, some bell ring in somebody's mind that why can't we have a free Tata Sky? That how can why can't we have a free Tata Sky whereby we can hack Tata Sky so that you need not pay the monthly subscription. So he actually posted a video online on YouTube as to how to hack Tata Sky. The court took Justice Muralidhar, the court and Delhi High Court took a very strong exception to this, and he stated that set-top box cannot be hacked, and this is a kind of content which should be prohibited from being circulated because it actually causes a commercial problem, or I would say commercial detriment to Tata Sky. And the grievance has been noted by the learned single judge in the following words. It says that the grievance, it says that basically the video was an attempting to show that how encryption code of set-top boxes could be broken into and television channels content can be viewed freely without subscription. The learned single judge also gave the reason why he is restraining YouTube in this case. He says, it is clarified that the said in not because YouTube had violated any trademark Tata Sky, but because website hosted the offending URLs which required to be taken down. It was for that purpose alone the YouTube was a necessary party. So it what does this case is actually an example of an anti-circumvention law and a hacking law, which means that anybody cannot train someone to do hacking and circumventing the law, which is otherwise a breach of law in other laws. Like hacking is an independent defense. Nobody can teach anybody to hack, or nobody can teach how to circumvent a law because it's an illegality. So ultimately, it therefore that is an illegal content, and that should be taken down immediately. So this was the context of this particular case. The next slide. Okay, so now coming to the complex issues on social media. As I indicated in the beginning, there is a dilemma before the court whether to pass a global injunction or whether to pass a territorial injunction. Why this dilemma? Because the courts can control their own citizens, the courts cannot control the worldwide citizens or the people what they are doing. Any injunction order which cannot be entered by the national courts should not be passed because it is against the principle of comity. Now there are two examples which I would give for social media cases like this where territorial principle was actually followed, which was YouTube versus Geeta Shroff, which is of Delhi High Court, 17th May 2018. There is a versus Google India, which is again a territorial approach, wherein the content was actually done territorial, taken down territorially, and principle of territoriality has been followed. And thereafter, the next slide, which is a contrast view taken by the Delhi High Court. Now, this case is a significant one, which is Swami Ramdev versus Facebook, on which was decided by Honorable Ms. Justice Pratibha Singh on 23rd of October 2019. In this case, the salient feature of this case are that the court in this case has held that Section 79 of the IT Act has got an international effect or extraterritorial effect. And it says that because of the new rules of the IT Act, which is Rule 3 of 2011 amendment, the data should not be removed territorially, but should be removed internationally, globally. And the reason for passing this global order as against geo blocking was that because the content is uploaded from India, therefore, this since the server is in India, the computers which are internet, which is a network of network, can be disabled from here and the worldwide circulation can be prevented and the court has got full jurisdiction over the matter. Now I will read certain excerpts of this law so that it may become more clearer to the parties, to the audience. So one of the finding was amendment of Rule 3.2 of 2011 amendment, which was the plain that the platforms need to remove the content which is defamatory or unlawful expeditiously after receiving the court order. The next slide. The next slide says computers resource from where the disablement has to happen means network. The interpretation given that the computer disablement does not mean one computer, it should be network of computers. Next point was act of uploading vests the jurisdiction in the court. So if India is the origin of uploading of the content, then the order will be global in character because the starting point is India. This is the test which is laid down by the High Court of Delhi. The next slide. Removal and disablement cannot be restricted to part of that resource serving a geographical location. This I have already indicated that the order has to be. The data is further stored on different servers in different this should not mean that the court will lose the jurisdiction because the social media company also indicated in this particular case that the data is on multiple server, but the court insisted upon the residential requirement. It says that if you are a resident, if the data is emanated from India and you are based in India, I have a full control over you. And then the next point, which is geo blocking, is not practical as the access to Indians would be available due to data and information on foreign servers. So this was a sentimental concern of the court, which is that if Baba Ramdev is defamed, not merely in India, but otherwise on the world over due to the data being present on the foreign servers, so therefore Indians will be having access. But that part of the argument I would say requires a kind of discussion because if the book is blocked, like Salman Rushdie's book in certain countries, that does not mean that the circulation has to be blocked in other countries as well, because it's a country by country approach and policy by policy circulation. So this part of concern is one of the reason is additional reason, though this is a contextual reason maybe in the facts it may be right, but it requires discussion. The next point, the next slide. Okay, so this again says I will read the main starting star point, which is Section 79 of the IT Act has an extraterritorial application for illegalities committed outside India so long as computer system or network is located in India. Rest of the part I am not reading for the sake of brevity. The next slide. Then the court relied upon its own policy, the policies of the platform, which I have discussed. They say that they should have the takedown policies, and that and they should and that and the court orders should be there so that they should remove the content. And then it says about enforceability of injunction. The court says cases where enforceability of the injunction is an issue, the court do not grant extraterritorial injunction, but platforms like Twitter and Facebook are capable of enforcing. So ultimately, what I said in the beginning, that the injunction order cannot be monitored, the court repelled that argument by saying that if I direct Facebook and Twitter, which have their internal policies, and if I direct them, then they are bound to remove the same. So why can't we have a global order? So ultimately, this judgment, I would say, is the best articulation of a broader view, which is that there should be a global injunction. The next slide. Again, this is some of the salient features of the previous views only, previous case only, and these are the arguments or the additional reasoning given by the judge to justify global injunction. The next slide. Swami Ramdev's judgment is under appeal before division bench. Though there is no stay of operation of order, it was listed in January 2020. Thereafter, I think Justice Muralidhar was hearing the case. Thereafter, he got transferred because of some other issues. Then COVID happened, and then we are still. I think this judgment will come when there will be full-fledged arguments by the parties. So we are still awaiting some clarity from division bench if required in the matter. Okay, so conclusion. The conclusion is, I would say, I have given you number of examples for IP rights infringements, modern complex issues. I would say that infringement on e-commerce website and media invites similar kind of legal issue as which involve interplay of IP laws and IT laws. So ultimately, what I would say is that infringement in the social media and in the e-commerce is the future of the nation, because whosoever is practicing IP law, and at present when we are in COVID situation where everything is happening on internet, then if the infringement happens, that should be on a social media, the recourse is the court, and it is bound to increase more, because once we are getting familiar and becoming easy with the online talks, online webinars, online purchase, online transactions, so therefore people are also gaining tendency to sit at home and start infringing somebody's rights. So it involves interplay of IP and IT laws, because it's a mixture. Ultimately, IP laws are there for protection of the safeguarding the rights of the proprietor. IT laws are there to safeguard, sometimes to exonerate the websites, social media websites, or maybe platforms. So they take the refuge of Section 79 of the IT Act, which I've already explained. Next point, which is jurisdiction is a major hurdle to be crossed in the court, because the debate revolves around, most of the time, the skeleton argument of the overseas companies are that the court does not have the territorial jurisdiction. They don't want that the merits of the matter should be touched. They want that the matter should go away with the jurisdiction. But recent line of authorities like Baba Ramdev case and all other cases where like Telegram case, like Tata Sky case, it shows that the courts are now very have strengthened their jurisdiction, and they are exercising the jurisdiction effectively, so that no one should go scot free. Identity of the person, having the social media profile and ostensibly carrying out infringement activity can be one of the issues. Now, as you are aware, that impersonation is one of the key factors in social media infringement. So when we see intellectual property rights dispute, it is an important fact that to identify who is the defendant. Therefore, the identity crisis sometimes leads to a problem. But now we have got IT laws into place. It's possible to inquire from Facebook, from social media, one of my colleague, Mr. Kunal Khanna, is having the client, called Chingari app, which is a substitute of TikTok. Now he is also facing lot of issues. Lot many Chingaris are there. Sometimes sometimes is of identified individuals, sometimes of non-identified individuals. Those which are there for non-identified individuals, he writes them to the Google or Facebook, and then they try to take down the content, and the remedy is addressed. Now sometimes remedy is also addressed by not going to courts, and to that front I would say even the courts are right when they say that the internal policy of the company or of the social media website should be robust. So if the policy is robust, like in the case of Google or App Store, like I have given the example of my friend's clients, so in such cases, the remedy can be instantaneous and you need not go to the court. But that part also we have to learn. The business people have to learn in India, and they have to be more ethically, more correct, so that there should not be frequent infringement. And if somebody is catching hold of infringement, immediate remedy should be provided so that litigation should be avoided. The next point is principle of uploading under the current law determines the jurisdiction, which I have already shared with you, Baba Ramdev's case, which says that if the content is uploaded from India, then the Indian court will have the jurisdiction, and wherever it is uploaded, you can go to that court. That can be a criteria which is there. Next slide. Okay, so AdWords and advertisement in the social media is also one of the key area. AdWords, I had explained in my earlier webinar also. I will explain it now also. AdWords are the keywords which parties purchase to bring their advertisement up in the Google search so that they should be commercially benefited. Now, sometimes there is a clash between AdWords and a trademark. That is another kind of subject, complete subject, which requires a discussion, but it also leads to infringement sometimes, and that is also one of the area which is to be looked into, and that is also in the social media very prevalent. The next point is that on 23rd of July, which I have indicated earlier in the beginning, Government of India has passed consumer protection guidelines where the duties of e-commerce website and the responsibilities have been made more stringent, and the duties have been fastened. The most relevant rules are Rule 5.5 and Rule 7.5, which are relating to intellectual property rights, wherein if there is an infringement, then the e-commerce website must retain the records within themselves when they disable the profile, because infringer should be caught, and it should not be that immediately the social media website should remove the content. Likewise is the another rule which says that e-commerce website or social media websites are responsible if they guarantee that there is a genuine product. Like iPhone on the Amazon.com, then if Amazon cannot deliver the iPhone from Karol Bagh market, which is a non-authentic gray market, and can say that it is a genuine iPhone. Earlier they used to do that. I gave an example even in my earlier webinar. But now, since government has tightened their net, therefore, now that kind of guarantees which result into unfair trade practices will also lead to consumer actions. So that can also be one of the key areas which can be seen upcoming in the near future in the consumer segment. To sum up, I would say that modern kinds of IP infringements and its interplay with social media and IP litigation is very predominant. This is more so during these pressing and challenging times. As I say, the internet is a key mode of reaching out of people and marketing. Justice Kathawala's view of the mind changing powers of social media and fastening of responsibilities are to be kept in mind, and the debate is going to be everlasting and remaining unsettled for a long time from now. Tensions will continue to arise as the new laws and like the present rules and regulations are emerging from time to time, and the government are realizing that we need to fasten the liability and the responsibility over social media platform. Thank you so much. Next slide. Thank you. Any questions?
Thank you so very much, Sushantji. I think that was a very elaborate, a very contentful information for all the participants who have joined us today. And I will now open this up for questions. I think we already
Thank
have
you.
a couple of questions on this. Uh, okay, the first one is coming up
Okay.
from Mr. Pratik Chaudhary. It says, is it a compulsion upon the plaintiff to prove abetment or collusion of intermediary with main defendant, the seller, in view of the proviso of Section 79 of the IT Act?
See, I will give you an example as well as I will explain it in a very simplistic terms. Now, if the intent of the provision is that the business model of social media platform should be allowed to function, then they cannot be held liable on each and every. If we will not keep the benchmark or threshold to fasten the liability, then any aggrieved consumer or any person who is actually aggrieved by the purchase of the e-commerce goods or the social media marketing will sue the social media, and they will end up litigating and spending there most of the time, and they will not be able to actually do their business, which is the business module. In save that, in order to save the spirit of the business model, the provision is enacted in such a way wherein the social media platform can be only held liable or their liability is only attracted when there is some level of collusion or some level of aiding and abetting is proved, which is some level of participation is proved. If you will prove the participation, that the social media is hand in glove with the infringer and is trying to actually gain advantage from the infringer activities, then it will be more easier for the court to hold that the social media platform is the necessary and the proper party to the proceedings. Otherwise, the skeleton argument of the party is of the social media is that we are merely platform, and court will uphold that argument otherwise. So this is my view in answer to the question which my learned friend has asked.
Thank you, sir. One more point that he has, maybe it could be in continuation to his question. It said, given the fact that in Amway versus one MG, injunction was granted by Honorable Delhi High Court against intermediary despite Section 79 of IT Act.
Hmm. That part I explain. That part also I will explain. That Amway's case, and that has now been actually in Amway has been now overturned by Justice Muralidhar. So my learned friend who's asking the question, I would request him to read the division bench's judgment also. But I would say that in Amway, what had happened was that there was a local commissioner report where actually Amway's godown was raided, and there some incriminating material was found, and it was found that the material was ingenuine and was not genuine, and the Amway products were spurious. Therefore, the single judge was of the view that because the possession of a spurious good is a crime in a criminal law, therefore the injunction should be granted and the inference of participation can be implied. And that is the reason why the injunction was granted. There has never been a case where the inference of participation is not taken into consideration. Because once there is an inference of participation, collusion, commercial benefit, if that kind of concern arises, only then social media can be held to be directly liable. These are my answers. Though MWay has been overruled, which is also the thing which one has to take into consideration.
Sure. Thank you so much. Thank you, Pratik, for raising that question. I hope it has been well answered by Sir. The next one is coming from Urvi Dhanak. She says, could you please elaborate on privacy policy page essentials for bloggers?
Okay, privacy policy page for bloggers.
Yes.
Okay, so Kunal, if you are there, yes. So I will again repeat the privacy policy argument. Okay, so my learned friend should be there here, but
Yes,
I will say orally also. Yes, so just open that page about privacy policy. Just share that page for privacy right. Put to Swami judgment,
sure, sir.
which is fourth or fifth slide.
Sure, sir.
Anila ji, have you added?
Yes.
Have you allowed Meera ji to come? That my guest, which okay,
Yes. Yes. I had requested her to join in. I had spoken, I mean, I'd passed on the message to her, but I couldn't see her name unless she
okay,
joined with a
okay,
different name.
okay, okay. Audit session, maybe I will share with her. No problem.
No, okay, I think she messaged that she has joined. Maybe she has joined with a particular number without the name. So I'll read out. There are a couple of questions from her as well. So
Okay.
yeah.
Oh, I see. Okay, great. Okay, so okay, so privacy policy issues. Okay, this is the previous one, Kunal. Previous slide. I think privacy has already left. The previous one. Previous one. One more. This one. Okay. So the legal problems with the social media, one of the problem is privacy one. Now, privacy is also a penumbra of rights. It is not one right. If you read Justice Chandrachud's judgment. Now, if somebody writes about his personal spheres of a friend or a girlfriend, then it attracts privacy issues. If you write some autobiography for someone who is a live personality, and that also results into insult, like in the case of Prime Minister Manmohan Singh, wherein there was a movie called Accidental Prime Minister. It involves privacy issues. If you talk about some film personality, it can also involve privacy issues, partly personality rights, partly privacy issues. Privacy right also includes right to remain silent. So if our Prime Minister, Mr. Manmohan Singh, was a silent Prime Minister, that does not imply that actually that he was a bad Prime Minister. I would say that it was his privacy right silent. So ultimately, there are lot many issues, and possibly next time, if Anjula ji agrees, maybe I can have a webinar on privacy issues. Then I will read that 500 pages judgment of Justice Chandrachud, and I will again come forward and take this head on as a topic.
Absolutely, sir. Absolutely. I think you mainly
Hopefully,
touched up.
hopefully one of our colleague is able is satisfied. Yes, yes. You tell me. You tell. Yes. Sorry. Hmm.
Yeah, no problem. Thank you so much. I think the detailed answers are definitely going to help the people who are maybe, just the beginners are and are wanting to understand that, where they could, take the actions right before than actually falling into a pit.
Okay. So
Yeah.
now I think one of them I've seen just I've seen Ms. Meera's question, which is there on the chat box, which
Yes.
says that is there a judgment on territorial jurisdiction of e-commerce players? So my answer is Baba Ramdev's judgment is one of the judgment which gives some factors which can actually give you enable the court to assume jurisdiction. But there are other factors like part of cause of action. So I may give you an example of my client. I did one case on behalf of Laugh Factory, which is an international laugh club, and they like Sharma show. And the concept of Laugh Club started in from the state of New York, where it was stand-up comedy was prevalent earlier than when it was introduced in India. They approached me, and there was one person in Bombay who started the trademark called Canvas Laugh Factory. So since he was from Mumbai and I was in Delhi, in order to attract the jurisdiction of Delhi High Court, I actually booked the show from Delhi. And since he was taking the booking from Delhi, therefore the court assumed the jurisdiction to say that since he is taking bookings from Delhi, and if, therefore the Delhi court will have jurisdiction because a part of cause of action there in Delhi. So likewise, if anybody has to, if anyone has to sue, then the if e-commerce website has a commercial transaction happening at particular territory, then part of cause of action theory can also be utilized along with the Baba Ramdev judgment, which will also which is also helpful in certain cases like defamation cases and IP infringement cases. These are my views so far as jurisdiction part is concerned.
Thank you. I think she's raised another question which says, what is the responsibility of the e-commerce
Any other
players?
question?
Yeah, there was one more continuing question, sir. It reads, what is the
Hmm.
responsibility of e-commerce players to
Okay.
ensure that genuine and not counterfeit products are available on their sites?
Yes. So this is what I was saying. Responsibility of the e-commerce players, what they say about that, the policy is that since e-commerce is a platform, and in the platform thousands of people come for their business module, they can only have an entry level check. The entry level check which is there is that the party who is registering with Amazon or any other site has to have a registered trademark or has to have a pending trademark. Second is that he should declare that this product is genuine. Now, later on, if it is found to be spurious or infringing in nature, then the responsibility will only arise of the platform when you will prove that the social media platform is benefiting from this particular activity. If otherwise they will take down the listing and the controversy will be over. So responsibility can be fastened only with at the entry level. If they don't check the trademark, if they simply register it, then you argue that there is no due diligence. Otherwise, there is a consumer dispute because 23rd of July guidelines, they say that consumer can raise a dispute now. Earlier it was not there, but now new rules have come into force as recently as in July. So that part also may be considered for raising a consumer dispute. Hopefully this may answer the query.
Right. Thank you. Thank you so much, sir. And it was a real pleasure to hear your presentation, which has touched upon all of the points which were talking of the contents where people can take care of it. We also spoke about the Facebook, the various copyright issues, and especially the complex cases that have been come across on the social media thing and the various cases in relevance to them. So I'm sure the audience has been able to kind of get a very clear and real life picture from the cases that you have discussed. So thank you so very much. It was a real pleasure to have you on board,
Thank you so
and
much.
I'm sure we will come up with various other topics where we can
Thank you,
have
Angela ji.
your insightful thoughts on them. So, does anybody from the audience wants to raise a
I'm
question
grateful.
directly to
Thank
him?
you.
Thank you, sir. Anybody from the audience wants to raise a question can raise a hand or ask a question. All right. I think they're really satisfied with your presentation so far.
Thank you so
So
much. Appreciate everyone's being here and spending their time. And
thank you for your time, sir, and we look forward to having you on board once more with another important and intelligent intellectual property related topic coming across.
thank you. Goodbye to all. Thank you.
Thank
Cheers.
you, and
Have a
we will
nice day
thank
and
you,
weekend.
everybody. Thank you, sir. Thank you very much.